Hi, everybody. Bill Prince here again. Let's spend a little bit of time talking about Chapter 19 of our text, which deals with issues surrounding corporations, their purpose, formation, operation, and so forth. As noted, a corporation is a legal entity formed in compliance with the statutory requirements of its state of incorporation. That's important because, again, remember that corporations are not human beings. As we'll see and have discussed a little bit, while corporations are taking on attributes of human beings, such as having free speech and, in some cases, their own religions, they are, in fact, legal entities created statutorily. In the absence of a statute authorizing their creation, these things would not exist in nature. And again, corporation law is relatively state-specific. While there have been efforts to make corporation more federalized, if you will, I guess, or having uniform laws across the states, that's not been entirely accomplished. Corporations are owned by shareholders whose liability is limited to their investment in the corporation. So if I put $10,000 into a corporation, my liability should be limited, assuming that the corporation does everything right, to that $10,000. In other words, if the corporation produces a product that injures somebody or creates, hundreds of millions of dollars of liability, my liability should be limited to that $10,000 that I originally put in. Corporations are managed by boards of directors whose job it is to sort of point the ship in the right direction, and then it's run on a day-to-day basis by officers who are employed by the board of directors to keep the ship going. Directors are persons who are elected by shareholders, and they're responsible for the overall management of the corporation. As we know, sometimes directors are more active than others. Sometimes directors serve corporations in an honorary capacity. Other times directors are much more hands-on. Officers are those persons hired by the board of directors and responsible, again, for the day-to-day operations of the corporation. We've seen, through recent history that one of the reasons why corporations get into trouble sometimes is where there is really no arm's length distance between directors and officers, and the independence in running the company sometimes gets lost, where basically the officers are hand-picking the directors who then become not naysayers, but yaysayers for everything the officers want to do. Shareholders are the actual owners of the corporation. In terms of taxation, corporate profits are taxable to the corporation when they're distributed in the forms of dividends, but not when they are reinvested in the corporation and as retained earnings. And as we know, one of the disadvantages of the corporate structure is the tax structure, where there's that double level of taxation. Profits that are distributed to the shareholders are known as dividends, and profits that are not distributed to the shareholders but are reinvested are the retained earnings of that entity. One of the big issues we talk about when we talk about corporations is what exactly is the liability of a corporation when it comes to torts and criminal behavior. As Justice Thurlow, an old English judge, once said, corporations don't have a soul to save, nor do they have a body to incorporate. So if these are, in fact, legal statutory creations, then can corporations, be responsible for criminal and tortious behavior? And I think over the course of time, we have found that to some degree the answer to that question is yes. In terms of tort liability, a corporation is liable under the doctrine of what's called respondeat superior for the torts committed by agents or employees within the course of their scope and duties. So, for example, if a UPS driver goes out and drives carelessly and crashes into another motorist in the course of delivering packages, UPS is going to be liable for that driver's negligent behavior. What happens, though, if that same driver, at lunch goes out and has a bunch of drinks and then goes back to work, drunker than a skunk, and crashes into somebody? Could UPS attempt to avoid liability on the basis that driver going out and drinking and becoming intoxicated wasn't part of the course of their scope and duties? In terms of criminal liability, a corporation can be liable for the criminal acts of its agents and employees as long as criminal sanctions can be applied to the corporation. So, unfortunately, such as fines, unfortunately, as many people have argued, after the Wall Street collapse and a lot of the criminality that was going on in that time period, nobody went to jail. Yes, companies paid fines, but a lot of people would argue that, well, those fines, that's nothing to many of these companies, and they're just going to turn around and stick it to the customers in terms of higher prices anyway. So haven't quite gotten there yet in terms of criminal liability. There are corporate sentencing guidelines, and those sentencing guidelines or the Sentencing Commission, which deals with really all sort of federal criminal behavior or criminal behavior that's dealt with in the federal courts, has established guidelines for crimes committed by corporate personnel, resulting in significant increase in the penalties for those crimes. But again, we really don't see too many folks jailed relative to the number of folks working in the business world for wrongful conduct. There's several kinds of corporations. There's domestic corporations, which are corporations that are incorporated in a given state and doing business in that same state. So if I, created Show Me Motor Sales, I would do business here in Missouri and incorporate in Missouri. There are foreign corporations, which are corporations doing business in a given state but incorporated in another state. So, Walmart, Amazon.com, think of anybody doing business that's not incorporated here in Missouri but that has a presence here. Alien corporations, which are not run by people from Mars, but those are corporations doing business in a given state but incorporated in a foreign country. And as you note here, or as we note here, foreign and alien corporations do not automatically have the right to do business in a state other than the one in which they are incorporated. They have to obtain a certificate of authority to operate in those other states they want to do business. A corporation doing business in two or more jurisdictions can be a domestic corporation in one jurisdiction and a foreign corporation in another corporation. And again, that just makes sense. There's also a distinction made between private, public, and not-for-profit corporations. A public corporation is a corporation formed by the government to serve some public purpose. A private corporation is a corporation formed and owned by individuals and other private interests, generally to make profit. A publicly held corporation is a corporation whose shares are sold to and held by or on behalf of the general public or are traded on the public exchange. So General Motors, Apple, those kinds of things where you can actually go out and buy stock in those corporations. Privately held corporations, which are corporations whose shares are not publicly traded and may generally only be bought or sold from the corporation. So, in my Show Me Motors case, I may issue 100 shares of stock, and I have some, and my wife has some, and my kids have some. And then there's nonprofit corporations, which are corporations formed in many cases for charitable, educational, religious, or similar purposes, or organized and operated without the goal of making a profit. We've also seen the recent development of what are called B corporations, or public benefit corporations, which are corporations that are allowed to incorporate with the idea of being socially responsible. This isn't a class in business social responsibility, but we know corporations, sort of by their structure, are created with the goal of making money in mind, and corporations that are officers and directors of corporations who might go out of their way to be more socially responsible than profit driven can often get in trouble. And so we've seen the development of these things called benefit corporations, or B corporations, which basically are structured in such a way as where the profit motive is not the primary driving force of that business. We also have closely held corporations, or closely held corporations are those privately held corporations with a small number of shareholders and often members of the same family. So again, these are businesses that are started, and again, the stock is not publicly traded, and again, the stock is generally held by a small group of folks. And again, management of these closely held corporations resembles that of a sole proprietorship or a partnership, where many times the stockholders are also the officers, or also the directors, directors are also the employers and employees. And again, to protect against domination by a majority shareholder in these closely held corporations, the articles of incorporations may require more than a simple majority approval for board action. But again, when you incorporate as a closely held corporation, you can structure that sort of thing as you see fit in your articles of incorporation. One of the things about closely held corporations is because these are companies generally started within families or within groups of people who have relationships, you generally want to make sure that there's transfer restrictions put on the stock because, for example, if I have a son and he's married, to a woman that I might not like, or something like that, and then he passes on, and that stock ends up in the hands of the widow that I don't want to do business with. How do I prevent that from happening? So many times, when you create these closely held corporations and issue stock, you'll want to create a buy-sell agreement or an option of first refusal where before that stock could automatically be transferred to the widow, I would have an option to purchase it from the estate. And again, that's just to make sure that you're continuing to do business with folks that you want to do business with. There's also what are called S corporations and PCs, and of course S corporations are closely held corporations that are taxed like partnerships, while at the same time affording the ownership, the limited liability that corporations are good for. And as noted here, to have a valid S corporation, it has to be incorporated domestically here in the U.S. It can't be a member of an affiliated group of corporations, and it must be owned by individuals, estates, or certain trusts. It must have 100 or fewer shareholders. It can only have one class of stock with the same voting rights, and you can't have any non-resident alien shareholders. And again, what S corporations allow you to do is basically pass through the income so that it's taxed at the individual level, but at the same time you are afforded the limited liability that corporations have without the double taxation of that income. And then there are professional corporations, which are corporations formed by folks like lawyers, doctors, dentists, accountants, and people like that, again, to reduce members' exposure to liability compared to what they would face in a partnership. You see many lawyers incorporate as a PC. When I was in private practice, I was a PC. Again, I probably could have accomplished the same thing just as operating as a sole proprietorship. Really not a whole lot of tax advantages by incorporating as a PC. If I committed malpractice, that wouldn't protect me from judgments in that regard. So we've kind of seen PCs sort of wane a little bit, I think, and we've seen more limited partnerships and LLCs and things of that nature materialize. Again, incorporation is going to be driven by the laws of the state in which the company is wanting to incorporate. And again, the first step is to select the state of incorporation. And a lot of companies are incorporated in Delaware, and again, because Delaware has some very favorable corporate laws. However, you can incorporate in any state that you want to. You need to pick a name, and the name again can't be the same as or deceptively similar to that of an existing corporation doing business in the state of incorporation. And then the document that really sort of drives the operation of the business are the articles of incorporation. And again, you want your articles of incorporation to be pretty thorough, pretty detailed, because again, if there's disputes about how the company's to be run, who owns stock, and that kind of thing, this is the document that's going to be referenced back to time and time again. And then an incorporator is a person who executes the articles of incorporation. Once everything has been sent into the Secretary of State's office, and that's generally the office where corporations are dealt with and regulated in each state, a certificate of incorporation will be issued, which will authorize that business to go forward and create that fictional legal entity of the corporation and create the limited liability and all that good stuff. In terms of what powers do a corporation have, again, it's sort of hierarchical. Obviously, the Constitution, laws or issues and laws coming from the Constitution are going to take priority over laws and issues coming from state constitutions, which are going to take priority over state statutes, which control corporations, which are going to take priority over the Articles of Incorporation, which are going to take priority over the corporate bylaws, which are going to take priority over corporate resolutions. So again, a corporation can, put any sorts of powers in its articles of incorporation and its bylaws and so forth. But again, they're going to have to be consistent with state law, which has to be consistent with federal law, which has to ultimately be consistent with the United States Constitution. Companies also have what are called implied powers, which even though they might not specifically be spelled out in the articles or the bylaws, if it's sort of necessary and proper, I guess, to carry out the expressed powers of the corporation, companies usually have those authorized powers as well. There's a concept you need to be aware of called the ultra vires doctrine, or VIRES as some people refer to it. And ultra vires acts are acts of a corporation through one or more officers or directors that exceed the corporation's express and implied powers. So what happens if you get this article, the certificate of incorporation, which creates the corporation and gives you limited liability, but then officers and directors go out in excess of what powers that corporation has. And as noted here, if that occurs, there are these kinds of actions that are available. There's what's known as derivative actions, or stockholder derivative suits. And in those cases, the corporation's shareholders can sue the officers or directors on behalf of the corporation to enjoin those acts before they're committed, or if they commit such an act, to get damages for doing it. So again, if an officer or director goes out and exceeds their powers, and the company is damaged or potentially could be damaged, the shareholders have an interest in preventing that, and they can file a derivative action. The corporation itself can sue the officers and directors to recover those damages. And again, the state attorney general may seek an injunction to stop that act, or if it's bad enough, they can actually dissolve the corporation. Another concept that's important to understand in looking at the corporation as a business form is the concept known as piercing the corporate veil. And again, in a situation like this, one of the advantages of having a corporation is that limited liability that the stockholders have in the companies. But at times, owners, officers, and directors of the corporation will use that entity to commit fraud or other illegal conduct. And in a case of that nature, the person who's been wronged by that conduct can go after the owners by what's called piercing the corporate veil. So, if you have a bunch of millionaires who own a corporation, but the corporation doesn't have any assets, and the corporation does some sort of wrong, well, you sue the corporation and there's nothing to get there, when the money's all in the hands of the stockholders or the owners of the company. And again, if you can prove that those folks have, acted in such a way as to, treat the corporate assets as their own, not do the things necessary to keep the corporation in good standing, then you can basically try to convince a court that this corporation is just a sham, that, it's really these stockholders that are doing everything. So I ought to be able to pop that corporate veil and go right after the assets of those individuals, sort of like a partnership. So these are the kind of factors that a court may look at in deciding whether to pierce a corporate veil. That the plaintiff or the wrong person was tricked or misled into dealing with the corporation rather than the individual. That the corporation was never intended to make a profit to begin with, or it was insufficiently capitalized at the time of its formation. That the corporation was formed to evade an existing legal obligation. That the corporation does not have or has not observed the required statutory corporate formalities, doing minutes every year, keeping records up to date, filing franchise tax returns, all that kind of stuff. That personal and corporate interests are commingled to the extent that corporate ceases to have a separate identity from its owners. I mean, how many times have we seen businesses where the owners are, dipping into the till to buy personal things and that sort of stuff? All of those things can sort of go into this decision to pierce the corporate veil. And often we refer to what's called the alter ego theory of piercing the corporate veil. And again, that's where, you can't tell where the corporation starts and the owners stop. And that's what the alter ego theory is. And, again, commingling bank accounts, using corporate real assets as your own, and so forth. Again, not a good place to be if you're trying to avoid liability by having your corporate veil pierced. In terms of the structure of the corporation, again, as we've noted, corporations are basically governed by a board of directors, and they're elected by the shareholders. They're to serve for a period of time. Sometimes they're compensated, sometimes they're not compensated, sometimes they know a lot about the business, sometimes they're just friends of the owners. Lots of issues there. Directors are entitled to receive a reasonable notice and participate in all board meetings. Directors are authorized to inspect the books. They're authorized to be indemnified if there's some sort of liability imposed against them for being a director. So while they have those protections, though, they're also responsible for managing corporate decisions, for appointing, supervising, and removing officers and employees, and declaring and paying corporate dividends, and declaring when to issue stocks and bonds. Now, one thing we've seen is that if directors are just appointed because of who they know, many times they have very little interest in having an active hand in the management of the corporations, and oftentimes the officers will fill that void. And what we've seen is more and more director liability occurring, for basically negligently performing their duties. So, directors need to take these jobs seriously. In terms of the composition, again, it can be all your friends, or if you're dealing with like publicly held corporations, there should be both inside and outside directors. Directors, again, are entitled to be paid for their services. Directors have oversight authority, and generally majority rule wins. Directors are not authorized agents of the corporation simply by being directors. So the fact that I'm a director of, say, O'Reilly Automotive or General Motors doesn't mean that I can go out and incur debts or obligations or make contracts on behalf of that company. That's something the officers and employees would need to do. Generally speaking, directors are not liable for the personal obligation of the corporations. Again, we've noted that there's indemnity that's available to them. Generally speaking, in big boards of directors, there's lots of committees that deal with compensation issues, day-to-day business issues, audit issues, and that kind of thing. One thing directors have often gotten in trouble for, and we saw this a lot during the 2008 financial crisis, is when a business was basically run into the ground by its management team, and yet the directors were giving them huge bonuses and things of that nature. So compensation committees really came into play in that regard. Officers are the folks who basically do the day-to-day work of the business, and again, they're the folks who are hired by the board to supervise those day-to-day operations. They are entitled to be paid for their services. They don't share in the profits unless they have some sort of stock ownership plan. They are subject to the oversight of the board of directors. They are agents of the corporation. So unlike a director who can't go out and contract with other people in the name of the corporation, officers can. And again, generally speaking, unless the veil's been pierced or things of that nature, officers are generally not going to be responsible for the obligations of the corporation. Both officers and directors are expected to maintain a duty of care, which is to act in good faith. They need to demonstrate care that an ordinarily prudent person would exercise in similar circumstances, and they are obligated to act in the best interest of the corporation. Officers are expected to make reasonable decisions. They are expected to exercise reasonable supervision over fellow officers and employees. Officers are expected to attend and participate in board meetings and clearly indicate their disagreement with any decision of the board. And again, failure to exercise that care can result in the imposition of personal liability against them. There's a concept we talk about in corporate law called the business judgment rule. And generally speaking, under the business judgment rule, directors and officers are immune from personal liability for actions that result in harm to the corporation. Because again, sometimes you're going to, we're human. Sometimes we make decisions and they don't turn out as well as we expect. As long as we didn't make that decision, with an eye towards, ruining the corporation, sometimes we just have to chalk it up to experience and hope we don't do it again. And that's sort of what the business judgment rule talks about. And so, officers and directors who make decisions that may negatively impact the corporation are not going to be held responsible, again, so long as they act in good faith, so long as they were acting in the best interest of the corporation, even though in hindsight it didn't turn out that way, so long as they act within the care, or use the care that an ordinarily prudent person in a similar position would use, that the actions were taken within the corporation's power to act and under the authority of the officers and directors to act. And so, again, as long as they're making good faith decisions, even though the corporation may have some issues, negative, and the stockholders might, not benefit as much as they could have, so long as those decisions were made under this criteria, the business judgment rule will protect those officers and directors from those decisions. Directors and officers are required to place the corporation's interests ahead of their own, and many times we don't see that happen. But in terms of things that officers and directors shouldn't do, they shouldn't use corporate funds or commingle or confidential information for their own personal gain. They should not engage in self-dealing, where they are taking actions that benefit themselves rather than the corporation. They shouldn't compete with the corporation and other business entities. They should not have interests that conflict with the corporation. They should not engage in insider trading, and they should not authorize corporate transactions detrimental to minority shareholders without shareholder approval. So, again, you kind of know when loyalty is being breached when you see those situations. Shareholders, unlike officers and directors, now in a close-held corporation, many times the shareholders are the officers who are the directors. But in public corporations, again, the shareholders own the corporation, and their liability is limited to the amount of their investment in that stock. Shareholders are not generally entitled to compensation such as a salary, but they are entitled to a share of the corporate's profits through dividends. If the company dissolves, they're entitled to their share of the value at that point in time. Shareholders are not agents of the corporation. So in other words, if I own O'Reilly Automotive stock, I'm not going to be able to go out and contract on behalf of O'Reilly Automotive. And again, shareholders have limited liability up to the extent of their investment in the company. All right. You guys can review these last couple of slides on shareholder approval and litigation, but I think you have a good flavor of how corporations come into being and some of the issues that we need to watch out for. So we will visit with you again next week. Take care.